This meeting is called to order. This April 26, 2022 special meeting is called to order at 5:03 p.m. Mr. Clerk or Ms. Clerk, please read the roll call.
Councilmember Montero.
Present.
Councilmember Reyes English. Councilmember Valentine.
Here.
Mayor Pro Tem Patterson.
Here.
Mayor Vargas.
Here. Okay, so we will be led in the Pledge of Allegiance by Mayor Pro Tem Patterson.
We all stand to our feet, face the nearest flag, put your hand over your heart, and repeat after me. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mayor Pro Tem. City Clerk, please read the guidelines for oral communications.
Pursuant to Government Code Section 54954.3, the public should directly address the legislative body concerning items that have been described in the special meeting agenda.
Are there any communications?
Mr. Mayor, we received no emails regarding public comment for the special meeting agenda, nor do we have speakers for oral communications.
Okay, we'll give people the opportunity to call in, so we'll give about 30 to 40 seconds, starting now. Seeing that there's no call-ins, I declare oral communications closed. So ordered. Mr. City Attorney, can you read item number 4, please?
Thank you, Mr. Mayor. For purposes of this special meeting, we have retained the services of Andrew Jarrett, who will serve as a special counsel to the City Council for this meeting. Mr. Jarrett.
Good evening, Mr. Mayor, members of the City Council. My name is Andrew Jarrett with the law firm of Collin, Tuno, Highsmith, and Watley. I will be serving as your counsel, the City Council's attorney this evening. The first item on the agenda, the only item on the agenda for this hour, is an administrative appeal hearing decision regarding non-renewal and revocation of a business license of M&A Gabay LP at 12,000 Hawthorne Boulevard, pursuant to Hawthorne Municipal Code Section 516-003B. The Office of the City Attorney will be prosecuting this matter. The Office of the City Attorney has provided a recommended motion to open the hearing and then refer this matter to an independent hearing officer to hold a continued hearing to commence no later than May 12th. This evening, you received a letter from Daniel Friedman objecting to that process and making other comments regarding the matter. So before you, you have 2 options. One is to proceed with the hearing tonight. And the other option is to take the city attorney's requested action of moving this matter to a hearing officer to hear the matter. Okay. And I would recommend that you first address that facial issue of whether or not to hear the matter tonight by hearing Mr. Kim and or Mr. Lask, their statement as to why they're making that recommendation, and then hearing Mr. Friedman's statement as to why that should or should not occur, and then make a decision on whether to proceed on that matter after we discuss it further. Is there an objection to that process, Mr. Friedman?
No, Mr. Rohr might want to comment as well, but no.
Certainly. All right. So, Mr. Mayor, that's what I would recommend, is that we turn the floor now to Mr. Kim, and for purposes of formality, to open the public hearing at this point, just so that there's no dispute as to what might be part of the public hearing.
Mr. Jared, what is advised, that I officially open the public hearing, or it has been opened just by mere entry into the special meeting?
I would recommend that right now that you, as the mayor, declare the public hearing open.
Absolutely. I will declare the public hearing open, and I'm going to ask if there's any comments from the public, first of all. Are there any comments from the public, Ms. Santos?
No, we have not received any comments, sir.
Okay, I'll give 30 seconds for people to call at this moment. Give it an extra 10. Seeing that there are no oral communication requests or calls, I declare oral communications for the public hearing closed. So ordered. Mr. City Attorney, go ahead, sir.
Thank you, Mr. Mayor. Deputy City Attorney Sean Lask will speak on behalf of the City Attorney's Office. Sean, you're muted. And for the record, Councilmember Angie Reyes English has joined in. Sean, you're still muted.
No, I'm having weird feedback from my speaker for some reason. I apologize. I missed whatever was said.
So you missed everything?
Yeah, I thought that was everyone was hearing that, but I guess it was just me.
Okay, Mr. Jared, can you just briefly state what Mr. Lask needs to do at this point?
So, Mr. Lask, we have opened the public hearing.
Heard that.
So we just need to state the city attorney's position.
Understood. And I apologize. Again, I thought that was global. Thank you. Members of the council, counsel for the licensee has made allegations that members of this council have expressed biased opinions about the licensee, and the licensee, through its counsel, has made these allegations not only in the letter dated April 11th, 2022, which initiated this hearing, but also in the moving papers filed in the anti-SLAPP motion before the Superior Court in another case. Based on the consistent allegations, the staff recommends that the council adopt the recommended motion and vote to continue this proceeding in order to have an outside hearing officer provided by a company called California Hearing Officers hear this issue and render a decision on behalf of the council.
Mr. Jared or Mr. City Attorney, go ahead.
It would be appropriate at this time, Mr. Mayor, for, unless Mr. Kim has something else to say in that regard.
Just one added point is that to have the continued hearing to commence to commence by a date no later than May 12, 2022.
So, Mr. Jared, are we asking Mr. Friedman to go ahead, or at this point, or what?
Correct. For the purpose of discussing the issue of whether to continue this matter and have a different hearing officer stand in the place of the city council in making the decision on this matter.
Welcome, Mr. Friedman. Go ahead, sir.
Thank you, and Mr. Mayor, members of the City Council. The Hawthorne Municipal Code, I'm not an expert on it, but I've reviewed it in connection with these proceedings. Section 5.16.040 provides us with has two requirements. One requirement is that having already had this matter heard before a hearing officer, that was already done. The next step is an appeal to the City Council. We have a right to have the City Council hear this matter, and that is expressly required by the code. The second thing that is required by the code is that the hearing must take place within 15 days of the notice that we were given. And today is the 15th day. So we're entitled under the code to two things: a hearing today and a hearing in front of the council. And that has been our consistent position, and it is our position today.
So this is Paul Rohr, also Loeb and Loeb for Gabay. I want to put a finer point on this. So the first week of April, Mr. Lask wrote to us and said, you know, I think we can all agree that it's pointless to have this hearing in front of the council, right? We know that the outcome is going to be that you're going to end up in front of the Superior Court. So why don't we just wait? So we weren't the ones who said there, oh, the council's prejudiced. He said, it's fruitless. You may as well skip to the court, which is where it would go, right? Because the city doesn't have a right to appeal if they don't like the outcome, right? We have a right to appeal. So that's essentially saying, well, you know, we at the city attorney's office think the council's prejudiced, and you know, we may as well just waive now and go to the Superior Court. And we wrote back and thanked them, right, for thinking creatively, but we didn't think that was enough, right? We have to show administrative exhaustion. So I believe, like, if we really knew that coming in front of the council was pointless, that you were going to be unfair, well, then I think we could go right to the court. But we don't know that, right? Just because he told that to us doesn't mean that it's true, right? If you guys told it to us, we'd believe it. So that was our response then. So that sat for a while. Then a new attorney was retained by the city, and they called us up and they had a new idea. And they said, well, instead of doing that, which you had an objection to, why don't we just agree among ourselves to send it to a hearing officer? And again, I said, well, you know, I kind of like the rule of law, and the law says that this is what we do, that we go to the city council. And there's no provision to opt out of it, right? It says it goes to the city council within 15 days. Seems to me like that's a rule. We should follow it. Didn't seem crazy. I didn't think I was thinking of something new. I just thought, that's a rule. Let's do it. And now, the day before, we get a new thing that says, well, we are, you know, sort of unilaterally going to say, well, the council's not going to hear it. Let's send it to a hearing officer. And at this point, I'm like, wow, there's something they don't want you folks to hear, right? There's something that like we think that we have a right to be heard by the city council. We think that you have a right to do what you determined to do. Like, I mean, you know, obviously within limits, you have to give us due process, but you know, there's the letter that the city attorney sends to you says, oh, you know, essentially, if you find that this is correct, you must do it. Well, no, it's not written like that at all. You're the city council. Just because some person on staff decides to start, decides to do a license revocation, doesn't mean that you have to go along with it. Even, and we disagree with this. We think that the revocation is completely wrong, but even if it weren't completely wrong, you would have a right to say, well, we don't feel like prosecuting it. Like, this is not the right way to get ahead. We think the right way to get ahead might be to, you know, work with the people who own the 25-acre mall that's you know, sitting in the center of our town, that you might decide as sort of an executive decision because you guys are the executives here. So it bothers me and concerns me why your staff is going to such a great length to keep you from doing something not only that you have a right to do, but that you're required to do. So we find that disconcerting. And we would hope that, you know, you elect to hear this yourself tonight, which we think is correct. And you can make your decision based on what's been put into the facts, but you can also say, we don't feel like prosecuting this, right? You have discretion whether or not you prosecute something. Now, I'm not saying that we've done anything. I'm just saying you might think, wow, rather than like spending more money on lawyers, and now, before there was one outside firm, now there's two, now there's three. And I like that. That's what I like about being a lawyer. It's like being the house. Doesn't matter whether you're right or wrong. It just matters that other people keep playing. But you guys might say, we're the ones who are responsible for the city of Hawthorne, and we don't feel like keeping playing. We feel like coming to some sort of solution with the folks over there at the mall. That's within your rights. Thank you.
Mr. Mayor, I think it would be appropriate for the Office of the City Attorney to make a rebuttal statement. And then after that, for Mr. Friedman and Mr. Rohr to further rebut.
Can you hear me?
Yeah, we can hear you. Go ahead.
So, of course, tonight of all nights, I'm having problems with my speaker. Can you hear me now?
Yes.
Okay, so I'm talking through my phone and looking at you on my computer, so hopefully this works. Unfortunately, as I said, again, I missed most of what Mr. Rohr has was stating, but so perhaps Robert might be able to address things a little better than me.
So let me just say this. What's fundamental here is the due process rights of a person licensed that's being revoked. And there are plenty of case law that says that if there is an accusation of bias, that it's out of abundance of caution that we take it to a fair, impartial. What we're trying to do here is set it up with a impartial hearing officer that is either a retired judge or of an attorney that can make a fair decision. There is a long history of this Hawthorne Mall and City Council. So out of abundance of caution, the City Attorney's Office, without saying that council is biased, out of abundance of caution to preserve due process rights, to have this heard, since we opened the hearing, to have it continued in front of an impartial hearing officer that has a legal background. That's simply what we're asking to do. And in the long run, that's what the attorneys of the Gabays want as well. They can't stay here and deny that that's what they desire and that's the goal. And so it's a simple request. It's to seek fairness so that we have a protected, preserved legal record should this case go to Superior Court, should they appeal to the LA County Superior Court. That's simple thing. That's the only simple thing that we're seeking to do. And by the way, the anti-SLAPP motion, which accused the City Council of bias, was well before what Mr. Rohr had mentioned. And I'll submit on that.
Mr. Rohr Friedman, would you like to provide further rebuttal?
Members of the council, on the issue of bias, our position is simply that if any member of the council feels that he or she is biased and cannot render a fair and impartial decision, then he or she should recuse himself or herself. That's all we've ever said. And that's basically a matter of common sense. I have not heard from anybody representing the city that there is any code provision that says that anybody other than the city council hears our appeal, and that the appeal may be heard beyond 15 days. The code provision I cited is clear and explicit. We are entitled today to a hearing before the city council. The code says that the city council is going to hear this. And we simply want the code to be implemented the way it is written. And we don't accept the characterization of others as to what we want. We want the code to be followed, and we want our rights under the code. That's all. Thank you. That's all I have on rebuttal.
May I just respond to that statement alone? Where in the code can the council refer to where the city council would have to recuse themselves? You want to stick with the code, so please tell us where in the code does the council have to recuse themselves?
I am not aware that the code deals with recusal. And if it doesn't, it doesn't. We simply said that as a matter of fairness, if any member of the council believes he or she cannot render a fair and impartial decision, then that person should recuse himself or herself. If you feel that there's no basis for that, then we'll proceed with the full council, whatever you think is appropriate. We've simply stated our position. That doesn't mean that we ignore the code and we go to somebody other than the council to hear the appeal, which is a violation of the code, and that we hear this beyond today, which is also a violation of the code.
So the code does not specify exactly what the council have to do. The council is required to open a hearing for the purpose of appeal. There's to set a date. They're required to fix a date for this appeal hearing. Thereafter, there's no specific requirements of exactly what a council has to do. Staff is simply asking that we follow due process out of abundance of caution, in all fairness, and set this matter for an independent hearing officer to hear the case for both sides.
This has already been heard by an independent hearing officer. We don't want to do that again. We're spending an enormous amount of money. We already did that. And then the code says that it's heard by the city council. So the code wants the city council to hear this, not an independent hearing officer or anybody else. There is no provision of the code that says that our appeal is going to be heard by anybody other than the city council.
Are we in a position to go ahead and just make a motion either way, Mr. Jared, at this point?
Yes, so at this point, I think the parties have spoken on this. I will advise the council on this matter. The code does say, as Mr. Friedman has stated, that a hearing must be set within 15 days and heard by the council. It's my understanding that in prior pleadings on the slap motion that that respondent side has made allegations regarding bias of certain council members on this matter. And it is my understanding that the city attorney's office is acting in reaction to that in order to preserve some due process issues. Further, respondents council is objecting to that and insisting that instead the code should be followed and the city council should hear the matter. There is law on this dealing with when there is bias, and there is a third way of dealing with this. The first way is that the council, as Mr. Friedman is suggesting, that this council hear the matter right now, all five. And any one of the five who feels conflicted recuse themselves from further participation. Mr. Kim raises the issue of a creative solution to that because the respondent has raised the issue of bias, that the matter be heard by a completely different body. The third alternative that has not been discussed is proceeding with this council, but those parties who are biased or allegedly biased be removed from the council. And if that results in only one or two members being present, it would be required that 3 members at a minimum participate. So what is called the rule of necessity is invoked. Because the situation of bias is present, then that disqualifies certain members from participating. And so what would happen then is 3 members would be selected from those, actually I should say, of those who are biased, allegedly biased, there would be members selected at random to then come up to the minimum number of persons, 3, to participate in the matter. So if, for instance, prior allegations have been that 3 members, council member A, B, and C, are biased, D and E have not had allegations of bias against them, then members D and E would remain, and 1 member would be selected at random from members A, B, and C. That is a way that the law allows for the reconstitution of a board when issues like this are raised. So you have 2 options. One is to go with reconstituting under the rule of necessity, or the other is the proposal by the city attorney's office to proceed and push this to another body for the other body, the hearing officer, to render a final decision in that. If it goes to that hearing officer, final decision is made, and it would not be coming back to the city council. Next stop in this matter would be Superior Court on a writ. And it sounds like Mr. Freeman, Mr. Rohr would indeed be proceeding in opposition to that decision.
Sir, is that it?
So those are your options.
Okay, I will make a motion that the city council open the hearing and then refer to this appeal. I make a motion that the city council open the hearing and then refer this appeal to an independent hearing officer to hold a continued hearing to commence no later than May 12th, 2022.
Second.
Roll call vote, please.
Councilmember Montero,
Yes.
Councilmember Reyes English,
Yes.
Councilmember Valentine,
Yes.
Mayor Pro Tem Patterson,
Yes.
and Mayor Vargas.
Yes.
The vote reflects mayor and council members voting yes.
Okay. Any further comment from council members or staff? Mr. City Attorney, go ahead.
No comments. Thank you.
Okay. Mr. Jared?
Nothing further. At this point, the hearing remains open as it proceeds to the appointed hearing officer.
Have we satisfied everything we need to do at this point in its entirety? Okay.
I have a question. May I ask a question?
Go ahead.
How will the hearing officer be appointed?
Oh, go ahead.
So we're going to reach out to the opposing counsel and see if we can reach an agreement with a retired judge or a referee. We're going to attempt to do that. If we can't reach an agreement, there is a specific agency we could just let them randomly pick.
If there's nothing further from council members or staff, this meeting is adjourned at 5:32. Thank you.